Today, on this episode of The Crossover, we will be discussing the Supreme Court of the United States. Is there a better system? With Professor of Law and Associate Dean at the University of Miami, Charlton Copeland. Learn how we should fix the current Supreme Court system, which is antiquated and ill-equipped to best serve modern-day America. Much more on this episode of The Crossover. Good afternoon, everyone. I'm going to be speaking with Professor Charlton Copeland about the United States Supreme Court. Certainly has to be a better way. I'm sure everyone agrees about that, but we'll delve into it. How's it going?
Good. How are you?
I'm all right. Listen, thanks for joining us. I'm very excited to talk to you about this topic, and I think a lot of people are certainly interested about this topic, considering what's gone on. I'm going to do a brief introduction just while we're getting all our listeners on here, but we have the pleasure of speaking with Professor Charlton Copeland, who's a colleague here at the University of Miami. He's a nationally recognized constitutional law expert. As I said, he's Professor of Law and Associate Dean at the University of Miami, where he's been here since 2007. He has served as the faculty coordinator of the Florida Supreme Court Internship Program, as well as the law school's Washington, D.C. Externship Program. He is a recipient of the prestigious Richard Hausler Award for his academic contributions to the student body. He is also a recipient of the Dukeminier Award and the Michael Cunningham Prize for Best Law Review Articles. He is a graduate of Amherst College, Yale University, and the prestigious Yale Law School. Here today, as we discussed earlier, to go over the United States Supreme Court. Is there a better system? So again, thank you so much for joining us, Professor Copeland.
Thank you for having me.
Let's just start with basics. When and why was the U.S. Supreme Court founded?
So the U.S. Supreme Court was founded in the midst of the framing of the Constitution in the post Articles of Confederation period. There was a real concern about the extent to which rights would be protected by the strengthened central government. The Articles of Confederation created a fairly weak central government, a central government that did not have the ability to tax, did not have the ability to regulate with very much vigor, and that quickly, in the aftermath of the revolution and the debts that had accumulated in the aftermath, underwrote a move to strengthen the central government, and that strengthening, right, caused some degree of concern about the safety and security of rights of individuals, but also some concern about the extent to which the politically elected branches, both the presidential branch, Article 2, and the legislative branch, Article 1, would be constrained. And so, again, the framework of a kind of separation of powers values to protect individual rights and freedoms gave rise to a concern that we needed an institution that was at some remove from the immediacy of politics.
And so, given that history, give us now a little bit of introduction into how the Supreme Court works. Who is on it, and what power do they have at any one period of time?
So the Supreme Court is occupied presently by 9 justices. That has not always been the case. That number was not set by the Constitution, but for the most for the greater part of our life as a country, we've had 9 justices. Those justices are appointed by the president, confirmed by the U.S. Senate. They serve for terms of good behavior, which has been translated into essentially life tenure, unless they are in fact impeached in the same way in which the president would be impeached and tried and removed. There have in our history been attempts to impeach Supreme Court justices. The Supreme Court has risen in esteem, as our listeners should know, at the beginning of the life of the Supreme Court. Our first Chief Justice left the Supreme Court to go into politics in New York, John Jay. And so the Supreme Court has not always enjoyed the kind of esteem that it has, but particularly in the post-Civil War era and in the 20th century, the Supreme Court began to take on an imprimatur of a real co-equal branch of, again, the elected branches, and all of the current justices are lawyers. Most are former judges in the federal system. Only one at present did not serve as a judge before she was appointed, Elena Kagan, and so it's a much more professionalized judiciary than has been the case in large parts of American history. Right? Some, the New Deal judges, for example, many of those judges were former senators, and so they had much more political backgrounds than is currently the case.
Now, their power seems to be kind of unrestricted. Currently, are they allowed to re-review any law? Is there any system of checks and balances when the Supreme Court wants to make a change to constitutional laws?
So this is a really great question. So one of the sort of early cases in the Supreme Court's life, a case called Marbury-Madison, the court articulated the doctrine of judicial review, saying that it was the province of the courts to say what the law is, meaning the constitutional law primarily. And that has in large part been the case, although that has not been uncontested throughout the court's history and throughout American history. That said, the court is constrained by the grant of authority that it received in Article 3 of the Constitution. What do I mean by that? The court is constrained by the requirement that the cases that it will interpret the Constitution only as a result of actual cases and actual disputes. And so there must be a live dispute between live litigants that comes before the court seeking a real resolution. And we see that in doctrines like standing doctrine, right? That the plaintiffs or the parties before the court must actually have a stake in the outcome of the suit. That the suit can't be moot, right? That it can't be too early. It can't come too late, right? And so the court has interpreted its grant of authority as imposing some constraints that the Constitution imposes. Other constraints that we've seen throughout American history have been a recognition that Congress does, in fact, again, understood through Article 3 of the Constitution, that Congress has the authority to change and restrict the jurisdiction in United States history. I'm sorry, I just needed to get my power cord. When I moved this vertically, I took it out. But in American history, the Congress has from time to time stripped the court of jurisdiction to hear certain kinds of cases. Now that the extent to which Congress has that authority is itself a constitutional question, but those are at least two of the most prominent restrictions on the court's review of constitutional cases.
Now, I think a lot of people have issues with the overall structure. And as a constitutional scholar, I definitely want to get your opinion on this. Mm-hmm. 9 individuals, permanent job security, answer to no one holds them accountable, pushing their own moral opinions on the entire country. What do you think about that system? And is that the best system?
So I would say that there is some measure of accountability. Now, I'm a part of the system that thinks itself as a part of the accountability keeping structure. That is to say, judges have reputations. Judges have some sense of their legacy, some sense of their reputation. Judges in the main have been public figures. Again, to go back to sort of the mid-century justices, they have had some public reputation, some public renown, right? A former U.S. president in William Howard Taft served on the Supreme Court. We've had members of the Supreme Court leave the Supreme Court to run for president, right? And so there is this sense that presidents, much like that members of the Supreme Court, much like second-term presidents, are constrained, at least in part, by the evaluation of history, by the evaluation of their peers, by the evaluation of their reputations as lawyers and as legal thinkers. Now, the question is that enough? And to the extent that again, the judiciary has become much more professionalized, much more insular, to the extent that you are seeing younger judges appointed to the court, do these judges have the same kind of public reputation that you might consider necessary to impose the kinds of reputational constraints? I think those are absolutely worthy questions. And so I do think that there is some degree of constraint. The public criticism has some significance. Even if we think of, and we should, even if we, when we think of members of the Supreme Court as political actors, which they are, if we think of them as members of regimes, right, either conservative regimes or liberal regimes, Democratic Party regimes, Republican Party regimes, they are at least in some sense constrained by their hope that the decisions they make will not make it harder for their political regime partners to govern or to win electoral office or to succeed in policy making. And so, but those are quite, as you rightly know, those are soft constraints. And so there is a huge degree of residual authority outside of those bounds. Again, I think the hard constraint is impeachment, but that's not in our history something that's been contemplated much. And so I don't articulate that as, I think, a real constraint, although given our politics, it might be more in play than has been.
Now, what about term limits? I mean, it just seems like in any leadership position, it's been shown that at some point people plateau. The leadership qualities over time tend to diminish. Should there be term limits on these people who are running our Constitution?
I think that is a very, it's a smart question. It's an important question. I think it's a question that takes institutional design seriously, because modern constitutions, right? And if you think about the United States Constitution as we like to laud it as the oldest written constitution in the world, it is not a modern constitution. Modern constitutions tend to impose term limits. I clerked on the Constitutional Court of South Africa. The South African Constitution is a modern constitution written between 1994 and the post-apartheid era and 1996. Justices on the Constitutional Court in South Africa serve 15-year terms. They are, and in many instances, they go on to do other things. I think that this is a design feature that, in my mind, would update the court, would update its legitimacy, would keep its legitimacy connected to contemporary political moments, but also provide a measure of, and a significant measure, 15 years is not a short amount of time, a fairly significant measure of time for justices not to be concerned about the immediacy of their decisions, to be able to make decisions with a fairly lengthy time horizon. We see, again, to go back to South Africa, we've seen consistently a court in South Africa that essentially allowed a president to be prosecuted, right? I mean, when you think about the kinds of institutional pressures that a court might be under if you impose term limits as opposed to a kind of lifetime term, that court demonstrates that despite the presence of term limits, they were very consistent across a large swath of South Africa's history up to this point in pushing back against popular political majorities in Parliament and against certain kinds of presidential policies that they thought were inconsistent with the Constitution. So it's not altogether clear to me on an empirical level that you'd see less vigorous constitutional enforcement under a regime of term limits.
I mean, I think if you were to take a vote, I think most people would be in favor of term limits. It's just, how do you install term limits? I mean, who would be making that decision? It's probably the Supreme Court, and they don't want term limits, I'm assuming. So it would be almost like an impossible thing to accomplish. You have to go through the Supreme Court to get term limits.
Well, I don't know. I suspect that the Supreme Court might be willing to think about term limits. The question about term limits, once the machine is moving, that's the tricky part, right? So meaning, if we were going to go back to the beginning, I think you're absolutely right to say, if we said, look, we're going to have a constitutional convention today, you'd likely get term limits. The question here is, which party thinks that they are more likely to dominate presidential elections? If you are a party that thinks you are likely to dominate presidential elections, then is it in your interest to back term limits for justices? Because again, if we, as we should, think of Supreme Court justices as at least a part of some regime, right? Some ideological, partisan regime, at least when they are appointed, right? Presidents don't appoint opponents to the Supreme Court. They don't appoint folks who are going to undermine their policy objectives and their policy legacies. And so if we take that seriously, presidents want folks who are going to keep their legacy intact. And so that means that these are, at least at some point, real political actors whose ideas are consistent with the governing regime.
Which brings up a whole nother question, because in principle, the Supreme Court justices should not be influenced by politics, right? Like, they should almost be removed from that political arena when they're deciding.
Once that black robe, right? I mean, the sort of idealized theory of the judge is, once that black robe is on, you are not accountable to even to the president who appointed you. You are not accountable to the party that may have backed you. You are not hostile to the senators who may have voted against confirming you. You are beholden to the Constitution, and in many instances in American political history, that's been the case. That is to say, justices have, even recent justices, have surprised their quote unquote partisan colleagues, right? I mean, you think about Chief Justice John Roberts most recently in the Dobbs case. You think about Chief Justice John Roberts in the Affordable Care Act case, in which he voted against the sort of dominant members of what we would think of as his ideological brethren and sisterin to uphold the Affordable Care Act and to at least not overturn Roe v. Wade in the way in which it was overturned in Dobbs. And so we've seen that, but I think we've also seen, and this goes back to your point, we've also seen increased vetting by the executive branch. We've also seen a narrowing of the biographies of who gets appointed. I think presidents want to know that the people they appoint are not going to be subject to ideological drift in the ways that other justices might have been. They want to get what they paid for in some respects, and I think that means that there is a kind of hardening on the court, which I think makes conversations about term limits much more important. Because if you can't envision a court that will in fact remain open, then I do think that you're going to have huge disjunctions between the policy that the court makes and the policy that a majority of the country wants and that policymakers think constitutionally acceptable.
Now, let's talk about ideology, because you mentioned that. And I think that the politics in this country are becoming extremely, the politics are becoming extreme. There's very few moderates. Do you feel like the appointed judges are also following suit because of the extreme politics and also becoming more extreme in their ideologies? Very little moderation. Is that the same case in the Supreme Court as it is in general politics?
I think it is. I think that that the court divides on ideological lines in even in areas that they once did not today, and I think that is, but that in and of itself does not suggest that there is equal polarization. I do think that there's polarization, and I think that there's been drift to the left. I think there's been drift to the right, but I think it's been asymmetric. I think that the drifts to the right have been more prominent than drifts to the left. I think that, and I think supporters of the Democratic Party are sometimes find the Democratic Party too conservative on what credentials ought to be possessed by people who are appointed or nominated rather to judgeships. I think that you think about 30-some-year-old judges who are receiving life appointments, and those sorts of things are concerning. But I think that there's a temptation, and I think the Democrats have more recently yielded to that temptation to say, look, don't hate the player, hate the game, or join the game around this. And so I do think that up until this point, we've seen a kind of asymmetric polarization that might in fact be lessening, right? But again, that means the polarization is going to get is likely to get worse. Again, I think that my sense is that our framers thought that the judiciary would be peopled by people who had reputations, whose reputations weren't going to be built by the fact that they were judges, but who, in some sense, were making a sacrifice to become judges. And I think that increasingly that's not the case. And so when you've got people who have names because they are judges, I think that they are more beholden to their dance partners than I think was in fact contemplated by our country.
Well, let me ask it this way. Our country is extremely divided, and it's only getting more divided. Do you feel like the Supreme Court is helping or hurting that situation?
I think the Supreme Court is hurting that situation. I think cases like Citizens United that underwrite large swaths of money into the political process undermine the capacity of sort of non-elites. And again, that's on the left and the right? I mean, labor unions and for the Democratic Party and corporations for the Republican Party, right? The Democrats have not suffered financially in the ways that I think they thought they would suffer. And so this is on both sides of the ideological aisle that that huge amounts of money just means that policymakers are always on guard of offending some interest that could run millions of dollars in ads against them in favor of some other candidate. I mean, you see this in the increased polarization in the primaries. I mean, you see candidates, both, again, Republican candidates that I think the Republican Party wishes they could pull back, and Democratic candidates, right? And so some of that is about participation, right? Which again, I think the court has not helped in its decisions on voting rights, in terms of making it harder to vote, leads to both a kind of demoralization in the political process, but these fears that there is fraud. The Supreme Court gave sanction to narratives of fraud long before Donald Trump did. And it's not altogether clear that those narratives of fraud were any more empirically grounded than the ones that we criticize as the basis of the January 6th attack on Congress. And so I do think that the court has in part contributed to this division and to the coarsening of our politics.
Now, what about the idea of separation of church and state? That's kind of one of our founding principles, yet clearly, especially recently, not the case, right? Roe v. Wade, the concept that people are pushing their religious agenda on the general public. What are your thoughts on that?
You know, I think that that these are real concerns. I am, you know, there are arguments that underwrite, I think, an anti-Roe position that do not come from religious positions. I think that there have been legal scholars on the political left who criticized the Roe decision on the basis of the fact that it had empowered the judiciary too significantly, right? That the court looked like the court of the early New Deal era, in which the court was striking down on substantive due process grounds the right to regulate work hours and the like. And so there are people who would not be drawn to an anti-abortion position, but who were anti-Roe because they thought institutionally the decision should not have been made by the court. In fact, Ruth Bader Ginsburg, right, went on record in some sense criticizing Roe, the decision, not the outcome, because she said, look, we were moving in a direction in which the states were getting us there, and maybe the court did not belong. Now, I don't mean to say that the larger point you made is not correct. The things that concern me out of this court was the recent case involving the coach who prays after the game with a group of high school students, and we found that not coercive, right? That an authority figure who goes to the 50-yard line after a football game, who engages in public Christian prayer, is somehow minding his own business, exercising his own right to religious expression. Those are the kinds of cases that are deeply concerning to me because they have no sense of the relative power disparity. They don't have a sense. We had a long line of cases that seem to protect children in schools, that seem to suggest that we understood the potential coercive effects that it would have on students who, whether they were Christian or not, but particularly on students who did not share these beliefs and what it meant for their own sense of belonging. And so that, from a kind of separation of church and state ground, that's the case that concerns me. What concerns me again is the lack of concern about school vouchers and those sorts of things that I think the court seems to address very glibly without any sense of historical context. But again, I think you're right to say Roe is added to the mix because Roe plays a huge role in, right, the current coalitional politics of certain kind of ideological commitments. Again, the court is going to hear a case this term about the extent to which religiously motivated folks can withhold services from same-sex couples seeking those services. That that has the basis to undo much of our civil rights law, and we ought to be very concerned about that. And so I think we are on a trajectory that you've articulated, with which I am very concerned.
I mean, I just wanted to touch base on that because you just mentioned it. Many people feel like Roe versus Wade is the tip of the iceberg, right? It was the country had made so much social progress, and then Roe gets overturned seemingly for no reason, just kind of out of nowhere. And that people are worried now, like you said, contraception being at risk, same-sex marriage being at risk, and all the progress that's been made over the last 20 years kind of going in reverse. I mean, what do you see in the next 5, 10, 20 years?
So let me step back and say something else, because I haven't mentioned it, and I want to mention it, and I think that it was pregnant in some of the questions that you've raised to me. And I didn't dodge it explicitly, but I want to address it. The demise of Roe would look different if Barack Obama's nominee to the Supreme Court had received a hearing, right? Meaning the demise of Roe would look different if the same folks who denied President Obama a hearing on his nominee also had denied President Trump a hearing on his nominee with significantly less time before an election. So, right, you think about a court in which arguably 2 seats look as though they have been dealt with, at least in some significantly inconsistent ways, on the basis of politics, right? Then I think that magnifies the machinations, right, that have underwritten the arrival at Dobbs, because a one-term president got 3 seats on the Supreme Court. We had 3 consecutive 2-term presidents, each of whom only appointed 2 people to the Supreme Court. And so and 2 of those seats don't smell right. And so I think that the context in which we see what the court is doing is informed by that set of political machinations that clearly have not taken the institution into account, but have decided that they're going to use the institution as a pawn. And so I wanted to say that. But you're absolutely, look, I mean, Clarence Thomas says, look, I'm going to give you the agenda. I'm going to tell you what is up. I'm going to tell you that at the end of the day, we're gonna harshly look at everything that looks like substantive due process, right? That means same-sex marriage, right, and other kinds of cases in which rights have been articulated in ways that that don't accord with an originalist position of the Constitution, right? The Lawrence versus Texas, the case that overturned the criminalization of sodomy, for Justice Thomas, and I don't think it's only Justice Thomas. Those things are back on the agenda for the court to think about, and so I think that you're absolutely right to say the next period is gonna be a period in which I think the court's legitimacy is going to come into huge question if these are the moves. But I think that legitimacy is even more questionable in light of how this majority was configured.
Let's wrap it up because I know you're super busy. One last question. As a scholar, as someone who understands the Constitution better than anyone else, in your world, how would the U.S. Supreme Court function? What's the ideal situation?
I think that the ideal situation would be a situation of term limits, something that looked like, 15, 16-year term limits. I would want a system in which it is possible. I don't know how you do. Right, you'd have to sort of design this, that it is possible for every president who serves a term to appoint a member of the Supreme Court. So those terms would have to be staggered in some way, because I do think you need some presidential investment in the appointment process so that presidents don't begin to attack the court. I think that you've got to have some institutional investment in that. And so I think I end in part where you started. I think that I don't know how we get there, but I do think that you've got to relieve the pressure. Think about judges who stay on long after they are competent so that they can return the seat back to a president who appointed them. This is not the way this institution ought to run. You shouldn't get to pick your successor in the ways we don't like it in our elective politics, and it should not be the case for an institution as significant and as powerful as the U.S. Supreme Court.
I mean, well said. So many issues with the highest court in the land, and how we change it is yet another challenge. And I think, just like you said, the next 2, 4, 6 years are going to be so critical to see all the changes, to hopefully not take a huge setback with all the progress this country has made in the last 20 years. And so fingers crossed that it doesn't just unravel. And I appreciate all your time, because it's so insightful.
Can I say one thing?
Of course.
I want to thank you for, because I know you are busier than I am, for inviting me to have this conversation. I want to say to your listeners, this is too important to be left up to lawyers. This is too important. Do not, lawyers may bring a certain kind of knowledge because we're here, but this is too important a question to simply be left up to lawyers. That the moral imaginations and ambitions for our country extend well beyond folks who have gone to law school.
Amen. I'm going to leave it with that, because that was beautiful.
Thank you so much.
All right, Charlton. Have a great weekend, buddy. I'll talk to you later.
Thank you so much. I really appreciated it.
Take care.